All right. Welcome, everyone. Thank you for joining in today. This is our National REIA call for March, and we're going to do a legislative focus. Um, I'm going to jump right into a couple of things. We've got a busy agenda in one sense, but we've got a little bit of flexibility. So I do want to touch on a couple of things. One is a little later in our time here, we will be joined by our DC lobbyist, Matt Keelen. He was going to join us at 3, and then he got called up to the Hill, which, as you know, there's a major vote going on right now they're working towards. So we're shifting around a little bit. So we're going to start off actually with Justice Daniel Kelly in just a moment. But first, I want to say thank you to our sponsor, which is Home Depot, and appreciate their partnership over the years. So with that, I do want to give a disclaimer. We are not giving financial advice or legal advice. Although one of us here is an attorney, but we are not giving legal advice. Please seek out your own financial legal advice. And then I do want to give a special recognition to a friend of mine, and we are being joined while we are a national association. We are developing relationships around the world and joined today with Dr. Arnaldo Costiera with the Lisbon School of Business and Government and some of his students joining us. So I'll be speaking to them after this. So they're sitting in to see kind of the legislative process and what's going on here in the US. With that, we're going to jump right in. And many of you are aware of a couple of things going on. One of which is we've talked about Loper Bright, Chevron deference, and the impact that is having. And sometimes I explain it and folks kind of give me that blink look and go, how's that work again? So we've been expressing it, relating about it, and I've had the distinct pleasure of being able to get to know Justice Daniel Kelly, use the proper title, but former Wisconsin Supreme Court Justice and a partner and I guess the partner or associate is not the correct term for the being engaged at the think tank, which is NCLA, which is the we're talking about the New Civil Liberties Alliance, and they actually were the key activists and plaintiff with Loper Bright and moving that forward. And the insights that they are bringing to the table, and I'm going to share a couple of messages on the chat here. One is a link to Daniel Kelly. So I won't spend too long on his extensive resume, but I will say that it is great to have somebody of his caliber. And I encourage you to take a look at this for everyone. He is, as I said, as a former Supreme Court justice, you don't get there just by, showing up at law school and passing and graduating. So I do want to thank you for that. And he has been advising behind the scenes on some very interesting steps that we may be able to take now that Loper Bright is through, and how do we move forward with that? And that's kind of what I want to unpack a little bit today. But first, I'm going to toss it over, and Justice Kelly, if you'd like to say a few words and kind of introduce from there.
Great. Charles, thank you so much. Thanks for inviting me to be on the call today. I really appreciate it, and thanks so much for everyone who was on the call. And Charles, tell me again about how much time do I have?
So we have about an hour here, and I want to take first 30 to 40 minutes with us and kind of unpack a little bit. So even a little bit of background on going into Chevron deference and into Loper Bright and where that puts us presently. I was thinking was a good start.
Terrific. Well, and the reason I ask is because I've been told that I can be loquacious. And so I want to make sure that I'm not wearing out my welcome or stepping on anyone else's toes. But I sure do appreciate an opportunity to talk a little bit about the kinds of issues that you're addressing. And if I could, perhaps given the amount of time we have, I could do a little bit of place setting so that we can kind of get in our heads a good framework within which to consider these issues. So I'll start at a very basic level, something that I'm sure that all of you already know, but it's important to lay this baseline so that we understand what comes after that. So as you all know, we have three branches of our government: legislative, executive, and judicial. And the reason I start there is because I think it's important to get firmly in mind the nature of the authority that each of those branches exercise. It's easy enough to say that the legislature exercises legislative power. Yes, that's true. And the executive and judicial, of course, the adjudicatory function. But what does that mean? And then why is that important to things like Loper Bright, Relentless, and the kind of work that you all do? So I'll start with this. I like to put the three branches on a timeline because I think that each of the branches of government matches up really well with each piece of a timeline. And to the extent that it doesn't, is because there's something specific in the Constitution that pulls that piece out of that timeline. So when we look at the legislative branch, we're looking at future-oriented things. So it's the responsibility of the legislature to peer into the murky future and figure out what laws will be appropriate to contribute to human flourishing. So they are entirely focused on the future. What laws will govern our actions tomorrow and every day after that until they change the law. The executive takes for himself the present. So the executive, and his role is largely derivative of what the legislature does, right? So the responsibility of the executive is to say, I'm going to look at the work of the legislature, and then today, and every tomorrow as it becomes today, I'm going to implement that in a fashion that will contribute to human flourishing. And then, one spot left on the timeline, one branch of government, the judiciary takes for itself matters of the past. Now, here's why that's important in our conversation about Loper Bright and the responsibilities of the judiciary. The courts always look at things that have already happened. And the key here is that there is no room for politics in the work of the court. So I like to liken it to an archaeological dig, right? So an archaeologist goes out into the field and he's looking for two things. He's looking for a site that might have interesting facts, and then he's after the artifacts. And he goes in and he carefully excavates and he looks for those remnants of civilization. And from that, he builds a picture of what civilization looked like in the past. Now, in doing this, it's really important that he not bring things of the present into that archaeological dig site and contaminate the site. Because if you bring present things into the past, you'll get a warped picture of what the past was actually like. And the work of the court is very much like that. So when the court goes into the metaphorical archaeological site, it's looking for facts and it's looking for the law that existed at the time those facts occurred. Because we know from the legislature that they keep on doing their work, right? So the law tomorrow might not be what it is today, might not have been what it was in the past. And so the judges go into the past and they carefully unearth the facts that relate to the case before them, and also the law that existed at that time. And their sole job is to apply the law that they found to the facts that they found, and then render their judgment about what the one says about the other. Now, it's key because it's our responsibility to keep that work site absolutely pristine. We don't bring our politics into that work. We don't bring our preferences into that work. We don't bring today's laws into that work. We apply only what we find there. And so a proper jurist is always going to be leaving his politics and preferences aside and just dealing with the raw material that he finds in the past. All right, so what does that have to do with Loper Bright and Relentless? So the New Civil Liberties Alliance, we had the sister case to Loper Bright called Relentless. And I'd personally kind of like this to be referred to as Relentless because I think the name of the case was just fantastic. Really, I mean, it just took so long, so much effort to get to a place where we would overrule the Chevron doctrine. All right, so why was the Chevron doctrine? Why was it developed, and why was it eventually overruled? Well, back when this doctrine, and the basics of the doctrine are these: when there is an ambiguous statute, the Chevron doctrine says that the court should look at the administrative agency, and all of those administrative agencies are part of the executive branch, right? So the court is supposed to look to the executive branch and say, well, what do you think it means? And then the administrative agency tells the court what it thinks it means. And the court goes, well, okay, I mean, I guess you're the expert, so we'll just accept what you say the ambiguous statute actually means. All right, now, do you see where there's a crossing of the lines between the responsibilities of the different branches of government? It's the court that's supposed to say what the law means, right? That's their job. And in fact, out of the three branches of government, it is the court that is the expert on that question, not the administrative agency. So the reason it's important that the court says what it means is because the executive agency deals with the present, and both the present and the future are politically oriented, right? So politics has its place. It's important when it plays its proper role, but politics deals with the question of oughtness. What ought our laws be tomorrow? How ought we to implement those laws today? That's the question that politics answers. But like I said, the court, it's got nothing to do with politics. And if the court tried to use politics in its work, then it would at that point stop doing the work of the judiciary, because those two things cannot mix. The adjudicatory function and the political function. You're doing one or the other. So when the court was looking to the executive branch, a political branch, to determine what the law means, it was abandoning its responsibility and its duty to declare, as Chief Justice Marshall said all those years ago in Marbury versus Madison, that it is the court's chief job to say what the law is, right? Not to make it, not to change it, not to eradicate it, but to simply speak what the law already says. So what Chevron did is it politicized the process of determining what the law says. So when that came up with Loper Bright and Relentless, the court looked at that and said, well, wait a minute. Why have we been giving our authority to a political branch to politicize the law? Is that something that is appropriate for the judicial branch to do? And the answer, of course, is that it is not. And this is not the only question that is being addressed recently with respect to the duties of the different branches of government. There is a significant amount that has been allowed to get politicized. One of the other cases that addressed the politicization of the law was also decided last term. It was called Jarkissi. It was an SEC case. And the question there was, when the government comes after you to enforce the law, can it do that in its own political courts that they've created inside the executive branch? Or do they have to go to the judiciary? And for a very long time, the answer to that had been, why, yes, the executive branch can be all things in an enforcement action. And so what you often found, not only in the SEC, but in enforcement actions across the executive branch played every single role except for the defendant, right? So it was the prosecuting party, it was the prosecuting attorney, it was the judge, and it was the jury. And your role as the defendant was to sit there and hope for mercy from an agency that played every single role in the adjudicatory process. And Jarkissi looked at that and said, yeah, no, I don't think that's right. And its ruling, which was relatively limited, but I think will have ongoing impact, and it'll broaden over time, until this gets back to the proper arrangement. The Bureaucracy Court said, well, look, when we look at an enforcement action, we're going to look to see if there's a common law analog to that from back in 1791 when the Seventh Amendment was adopted, which promises you a jury trial in most instances. And so the court said, well, if the statute looks like an analog of a common law theory, then the Seventh Amendment applies, and then you can't be prosecuted in the political courts. You have to go to the real courts in the judiciary. Now, like I said, that's relatively limited because it focuses on whether you have a right to a jury trial and whether there's a common law analog. And it's all very technical. But I think that they put the down payment on the theory that we're going to start returning judicial authority to the judiciary. So just like the judiciary was reestablishing its authority to say what the law is, that was the Loper Bright and Relentless cases, then Bureaucracy says, now we have to determine where are these enforcement actions going to be heard. And we think they need to be heard in the judiciary. And that's key, especially, and I don't need to tell you how much regulatory material you have to deal with and all the manner of enforcement actions that the federal government and state governments may wish to pursue if they believe that you've run afoul of any of the regulations. But this will be key to you going forward because, you know, if you take a look at statistically at the success rate when an administrative agency pursues an American citizen in their own political courts in the executive branch, you might not be surprised to learn that their success rate is shockingly high. But then when they come out and they go to the judiciary, that success rate drops dramatically because now they're not deciding their own cases, right? So in an administrative court, in a political court, essentially the agency is deciding its own case because it's fulfilling all of those roles. The agency decides who it's going to pursue. So it already believes that it has a good case against you. The prosecuting attorney is going to be, it works for the agency. The administrative law judge works for the agency. The administrative law judge performs the function of a jury, and he, of course, he already works for the agency. So the idea that the agency would decide to bring a case and then at some point in the prosecution decide, oh wait, no, I'm full of hot air, I must dismiss my own case, is ridiculously low. So what we want to do, what we want to accomplish is recapture the protections that the Constitution granted to us as inalienable rights. A right to have our cases heard in the judiciary, where the decider of the, where the speaker of the law, the judge, is not dependent on a political agency or a political constituency, and where the fact decider, whether that's the judge or a jury, is similarly independent of the political branches. Now, back in the day when the United States was started, this is one of the things that caused the colonialists to take up arms against the British, is that the king had made the judges dependent on his will. Their concern was they would not have independent adjudication of their cases. And so that was one of the casus belli, as they say, that brought us to conflict, and after which we decided to go our separate way. But since I'd say about the last 80 years or so, politically, there's just been a move back towards that model that we rebelled against, making the judges accountable to political players, making the fact deciders accountable to political players. And of course, those are both contrary to the structure of the Constitution. So a lot of the work that we do at the New Civil Liberties Alliance is pursuing cases that we believe will be necessary to preserve our civil rights by shoving the administrative state back within its proper boundaries. There is a role for administrative agencies, but that role is simply to implement the law subject to the president's guidance. It is not there to make the law, and it is not there to try cases. And so we bring cases that bring that point to the court for them to decide. And so Charles was Charles and I were talking over the last several months. One of the things I mentioned to him was that we are always on the lookout for cases that are aimed at protecting those civil rights. And I just want to make this available to you. As Charles mentioned, I don't know if you mentioned our website. It's NCLA, stands for New Civil Liberties Alliance.org, ncla.org. And should you have any questions, if you have a case where you think that the executive has been making law where it does not have authority to make the law, if you have a case where a judge has been deferring to an administrative agency's interpretation of the law when that's no longer an appropriate thing to do, or if you're in a case where an agency has brought an enforcement action against you and wants to pursue that case in their own political courts instead of the actual judiciary, give me a call. Go to the website. There's a way, there's a method there to contact us, and just say that, you and I talked on the Zoom call. Remember my name, Daniel Kelly, and that'll get to me, and then we can take a look into that. And one of the reasons I want to make that available to you, I know that dollars are precious, especially these days. They don't go quite as far as they did a few years ago. But we are a public interest law firm, which means that we don't charge for our services. There's no hourly rate. There's no charging for fees. So we handle the financial obligation involved in a lawsuit on our end, so that you don't have to. Because we think that the protection of these civil rights by pushing the administrative state back inside constitutional boundaries is that important, that we want to make our services available to you when you have an appropriate case. So, Charles, I don't know if you have any questions you'd like me to address, or
I do actually. I want to bounce a couple things off everyone, and just as a brief reminder, this is recorded, and we will share it out to everyone as well. So I encourage you to share this to your local attorney friends, local legal friends, and make sure they are aware of the opportunity that we're presenting. Because as Justice Kelly just mentioned, that is not a light statement. When we have a consolidation of powers in the bureaucracy, functionally the executive branch, this is being separated out. And I can tell you, Justice Kelly, that I got a call yesterday from somebody who's dealing with a state court and a state administrative office that is judiciary that just ruled against them. And of course, they have a 90+% where they always rule for themselves. It's actually higher than 90. It's not quite 100, but I'll put it that way. The ones that they don't like necessarily, they ship out and just go, oh, well, no case there, and make it go away rather than actually rule against themselves. So that's one where 87 pages to say, no, we're right. We made the rule and we're right about our rule. So those are the kinds of things that are very interesting. And I will mention from another side of this is oftentimes we see fair housing issues that are brought up. And this is always one of those sensitive areas. People are like, well, you're talking fair housing. Oh, no. But let me just mention to you, and I had a very off the record conversation with one of the enforcement agencies, and they were very clear. They said, yeah, if we didn't have these, administrative courts, yeah, most of the stuff we bring forward, we probably wouldn't bring because we'd have to actually go to court and prove it. I'm like, did you hear what you just said?
Yeah. And part of the reason, it's not just that they've already presumed that you've broken the law, and that's why they're bringing the case, right? So they walk into the courtroom with a bias that you're going to lose because they think, well, I decided that you broke the law. So the likelihood I'm going to change my mind is pretty low. But also, there are additional structural reasons why it makes it really difficult to defend yourself in the political courts. One of those is they generally don't have to follow the rules of civil procedure. And one of the major problems with that is a lack of discovery. In traditional litigation, discovery is the process by which you figure out what the other side knows about their case, and then they figure out what you know about your case. And then, if it's necessary to subpoena third parties come in either as fact witnesses or expert witnesses, you bring them in with subpoenas. That's all. You do all that through the discovery process. In most administrative agencies, you don't have a right to discovery. The ALJ will decide, well, in this case, I will allow you to inquire into X but not Y, A but not B. And then you have to be satisfied with what the ALJ allows. So, and then on top of that, once you get to the hearing, most hearings are not governed by the rules of evidence. So the one of the reasons that trial lawyers are valuable is because they know how to present a case to a decision maker with evidence that is solid and useful. And by that I mean it's information that we are confident is accurate. It is not the product of bias, is not irrelevant or immaterial, right? But those restrictions don't generally govern when an ALJ holds a hearing. And a lot of times the testimony, it's not even sworn. So the witnesses for the state or the federal government don't even have the fear of a potential perjury charge if they lie on the stand. So it's not sworn oftentimes. In a real trial, it would be inadmissible because it's hearsay or it's irrelevant or it's immaterial or doesn't have any of the other indicia of reliable information. And so what you get is a hearing officer who walks in already disposed to rule against you and decides what information you get to see and what information you don't get to see. And then he can base his decision on evidence that would never be admitted in a judicial trial. So these are all of the problems. This is one of these are the reasons why it is so difficult to actually win a case in an administrative political court. And that's why we want to get them moved back to the judiciary where they belong, so that we have those constitutional protections, so only relevant, solid information can be used against us, so that we can figure out what the facts are that the government has and that other parties have, and make sure that that process comes together to have a fair adjudication.
I think that's an excellent way of phrasing it and stating the case. One of the things I want to just kind of reiterate is we are asking for cases with fact patterns specifically that you come across around the country that are related. One, if they're pushing into some sort of administrative court, that's the Jargosy case. And then also, if this is something that has been ruled on in the past, but this is a situation where the administration, the bureaucracy has said, we're going to take this interpretation and we're going to go this direction. Those are opportunities, Loper Bright / Relentless. This is the chance to come back and take a swing at that. The stare decisis statement within the Loper Bright Relentless case said that whatever was already passed is already there. It's sitting in place. We have to actually bring up each one of those scenarios. So, careful what you ask for. I always want to put a caveat on there, but we do want, if you've got something, you're seeing something, as leaders, as attorneys around the country dealing with these real estate issues, we want to make sure that we bring these issues forward. You can feel free to shoot them to me. I can take a review of them, get them over to Justice Kelly, or if you want to go straight to them, attorneys especially, feel free. I'm not an attorney. I play one on television and radio sometimes, but I'm not an attorney. And so if you want the straight to the legal opinion, by all means, feel free to do so. And I will just say again, Justice Kelly, thank you for even making that offer on behalf of NCLA. And I will mention there's a post that you did just recently, actually in January, that I found very interesting. Your reference to a man of all seasons in the article, I thought was extremely appropriate because are we a country of laws or are we a country of men?
Yeah.
And that question really comes down to the heart of what your article is about. And if you'd like to expand on that a little bit, we're going to share the link to the article out here momentarily.
Yeah. So one of the remembering back to the founding fathers and what their concerns were about the British government, the monarchy, and how they were going to respond to that and protect against the abuses that they'd lived under. Um, one of the things they understood was that the legislative power is the greatest power in government, the power to make the law. So at the one and the same time, it is the most beneficial to put in people's hands, but it still retains its dangerous nature. And so the trick is to figure out how to create a government that is capable of governing the governed, while at the same time requiring that it govern itself. And that's one of the reasons why all of this authority was split up amongst the three branches and then vertically between the federal government and the states. And then even within the legislative branch, split between the House of Representatives and the Senate. The reason was that consolidating power in the hands of one person is an extraordinarily dangerous thing to do. So what you want to do is you multiply that and spread it out so that ambition will counteract ambition. And so one of the things that we've been seeing over time is an attempt subconsciously, I think, but inexorably to undo the good work that the Constitution did. We're trying to unwind that dispersion of authorities across branches and across levels of government. We want to consolidate it in one place and then move it up, right? So we're trying to move state authority up into the federal government, and then we're trying to move legislative power and judicial power over into the executive branch. Now, as you think about that consolidation of powers, think about what that looks like, just as a practical matter. Compare that to what we rebelled against all those years ago. We're doing the same thing. We're recreating a monarchical style of government within our constitutional form of government, because we're not paying attention to that diffusion principle. And so, the play "Man for All Seasons," I find that to be just extraordinarily instructive because it tells the story of what happens when you disregard the law in an attempt to achieve something worthwhile, right? So in the play, of course, the king's counselor was being hounded both by the king because he wanted him to agree that his marriage could be set aside. And so there were people within the government that were after him to either bring him down or force him to acknowledge what the king had wanted. And so at one point, the suitor for the daughter turns to the main protagonist of the play, and they were talking about going after one of the bad guys who was trying to bring him down. He hadn't done anything wrong; he'd broken no law, and yet he was being counseled, "Go get him anyway." And then the key interchange took place. So Thomas says to Roper, "What would you do? Would you cut down the laws of England to go after him?" Said, "England is planted thick with laws, man's laws, not God's laws, would you tear all those down to get after him? And Roper said, yes, yes, I would. And I to get after the devil, absolutely, I'd cut it all down. And then Thomas responds to Roper and he says, and then once all the laws are flat, behind what would you hide when the devil turns on you? And and this is the dynamic that I see that we need to pay particular attention to as we address the use of authority in federal government. We have the separation of powers and the diffusion of power because these are the things that we hide behind so that we get the protection of the law. And if we say we are going to go after whatever malefactor the government thinks needs to be gone after, and we're going to take shortcuts, we're going to start trimming off parts of the Constitution so that we can do that. And if we agree with that, then once the government has finished consolidating all the power in its hands, what will be left to protect our civil liberties? And this is why we think at the New Civil Liberties Alliance, this is why we think it's really important, even if we might not agree with what a client wants to do, we might think it's unwise, and it may even be that there is liability on that person's part. And yet it is important that the law be followed when the government pursues him to impose whatever punishment is due. Because if we don't, if we allow that to happen without guarding those safeguards, without guarding those constitutional rights and that diffusion of power, that just makes it easier for the government to go after people who've not done anything wrong. And so we protect these laws so that we can protect ourselves. We protect these laws so that we may live at liberty in this great country of ours. So I apologize, Charles. That's probably a long way around to addressing that.
No, I think it was an excellent point. That's why I wanted to make sure we brought up that article, the reference to it. And I kind of laugh when I say careful what you asked for, but in the back of my mind, what I'm really thinking of is also, we're not asking for revolution. I have a friend of mine who ex-government and used to topple government, so tells you where he worked. And his comment was, it's not the difficulty isn't starting the shooting, it's stopping it.
Yeah.
And you look at the blood of the guillotines of the French Revolution, which just wouldn't stop until they put a dictator in charge, Napoleon. There's lessons to be learned there. And even as we're sitting here in, a real estate focus, 40,000 members across the country, small businesses and entrepreneurs, this government affects all of us and impacts us, and we need to be affiliated with those higher thoughts of why are we doing this? And that brings us really to, is this a battle worth fighting or not? And that's really where we're coming back to for those fact patterns when we start to, I don't want to say deconstruct the government, but deconsolidate some of the powers that have lazily, if I can say it that way, arisen. And I think they've lazily arisen because a Democrat friend of mine used to make the comment, he'd say, the difficulty of politics is in the details. If we want to pass something generic, we can agree on that. Okay, sure. And then it goes over from the legislative branch to the executive branch, and then the executive branch is going, okay, how do I do this? And that creates a scenario where, okay, well, this administration rules it this way, this one rules it that way, and we start getting this back and forth. It's not good for business, it's not good for law, it's not good for the country. And in one sense, Congress needs to do its job in detail, and that's at the federal level as well as at state levels. They need to work through what it really means to have this law impacted, not just go, hey, we got a high level agreement, let's pass it and move on. We've got to work through those details because the devil is in those details that if we don't work through, will turn around and bite us in the end.
That's right. And that's, and that goes back to the question of politics and the proper role that it plays. So we insist that laws be passed in the legislature because that's where the most diffused representation is, so that the people of the United States can decide what they want their laws to be. One of the reasons we object to laws being made in the executive branch, not just because the Constitution says that it's not to make the laws, we definitely object on that basis, but also because it's lawmaking in the dark. So unless you really, really go out of your way to hunt this down, look at the Federal Register every day to find out what's being proposed, and then have an attorney sit down next to you and explain to you what these things say. Because I got to tell you, when I read the Federal Register, sometimes I have to read an entry 2, 3, 4 times before I figure out exactly what it's doing. And I've been doing this a lot of years.
I
So,
appreciate you saying that. Yeah.
oh yeah, don't you? Yeah, if you find yourself getting hung up on federal regulations, don't you worry about it. We all do. So it's done in the dark, and it's done in a way that is, sometimes I think, intentionally dense and obfuscating, so that people don't know what the government is doing to regulate their lives. And so we want to move that back to the legislature, where we can be certain that the people of the United States are keeping their eye on what their representatives are actually doing. So I don't know if any of you read Jonah Goldberg. He wrote a book recently, maybe a handful of years ago now, called Suicide of the West. And in that, I think he had a really key insight. And this goes to your what you said, Charles, about lazily moving all this power into the executive branch. I think that's right, because this idea that we separate out the powers is not something that we come to naturally. We're kind of hardwired to think of there being one powerful person in charge, whether it's the king or the president or whatever it might be. We just imbue him with all manner of authority that he doesn't actually have. And we think he's actually running things. And that's not how it works, right? Yeah. So we separate that power out so that one person can't run everything. Because if that happens, the founders said that's the very definition of tyranny. So we protect these things so that we can protect our liberties. And if we allow these to migrate over time into one centralized repository of power, we will come to regret that.
With that, Justice Kelly, I'm just going to say thank you again. We've posted contact information for nclalegal.org on there. And then again, thank you for the offer on the fact patterns and a little bit of higher education refocus on this. We appreciate it. And I just want to say thank you again for coming on today. And we look forward to working with you a lot over the next couple of years here.
I do as well. Thanks so much, Charles. I appreciate you having me on this afternoon.
Absolutely. Thank you.
Take care, everyone.
So we're going to switch over. Matt Keelen has joined us here. Matt, are you squirreled away somewhere up on the Capitol? They pulled you into meetings here and there?
I am hidden in the Rayburn staircase on the 4th floor. Hopefully there won't be a big group that comes by. A ton of activity up here today. Everyone's running around trying to make sure they're not getting cut by Doge.
I gotta say Doge, and if the question that's probably on most people's mind is this CR going to pass? Is it going to move forward? Probably out of the House, but then where's it go in the Senate? Not that I need you to prophesy, but
yeah, I think that it'll pass the House tonight, and then they're looking to leave at the end of the night, so a short week. And the word on the Senate side is that they should have the votes as well. So we'll keep moving the train down the line.
Excellent. Well, Matt Keelen, for those of you who are newer, is with the Vogel Group. I just put his link in. Brad will share that out here shortly. We've been working with Matt for, has it been 10 years now or so, something like that.
Been a while.
It's been a little while. And from the housing side, and Matt's one of the specialties is in financial services, which is where housing gets lumped into. So I want to say a special thank you for Matt for all the years of behind the scenes and whispering in the ear and being able to, twist arms. We've worked together quite a bit on the seller financing side with the issues going forward there. But we've also got a number of other issues that we're going to be starting to look at, especially with potentially I don't know if it's a rejuvenation. It's just going to be a renewal with the Tax Cut and Jobs Act that Trump passed in 17, and or how that's going to work. But that could have a substantial impact on anybody who's in finance, in business, and especially in housing. So there's a number of issues there, from um, the carried interest to, if you've got like-kind exchanges, and even how you expense and how expenses are done. So those are all things that we're going to be looking at. Matt, I don't know if you have any insights along those lines, or if you're seeing other things that are kind of top of mind with legislators right now.
Yeah, so Charles, of course, as I'm getting ready to speak, there's a group of people talking loudly in the stairway. But we recently met with both Subcommittee Chairman Barr and Congressman Gonzalez about reintroducing the seller finance bill. So that should be done pretty shortly. We had one of our strongest group on the bill last Congress. We lost a couple people who were either retired or lost their election. So we've been trying to round up some new co-sponsors. We also met with your home state Senator Husted on last Monday and talked to him about coming over to REIA and doing a little town hall with you guys, as well as hopefully dropping the Senate version of the bill. Chairman Barr has let us know that he is looking to do a large affordable housing bill that may include some of your other priorities. As you know, he's just over the river from you guys in Kentucky. And I do think it would make sense to maybe invite him over to Cincinnati as well to talk about how we could be working with him on that broader bill. With a gavel on that subcommittee, he's going to have the bandwidth and the ability to get something done. And I do think he wants to try to pass a comprehensive bill that has bipartisan support and can get through and signed by the president. So this is a good opportunity, maybe a once in a decade opportunity to have some proactive pieces of legislation instead of always playing defense.
Excellent. Well, I've got some information for you that Dave Corsi has shared with me. It's something we've worked on quite a while ago. We'll be working on some of that. We'll be up next, actually in a couple weeks here, week of the 24th. It'll be 25th and 26th. We'll actually be on the Hill joining with NAA and participating in that group to do a kind of walk on the Hill, meet with some of our legislators. And bluntly, part of this is to be a partner with NAA and NMHC, which is National Apartment Association, National Multi-Housing Council, as they make their foray onto the Hill, and then be there as partners and to participate and be part of the housing coalition. Because the stronger, there's a whole group of us that as we get on there and make our voices heard, we are stronger. And we have kind of been able to flex a little bit of muscle in that we are a faster, more entrepreneurial based organization. So we were able to respond on things like, the eviction moratorium before, and able to respond with voter voice and get the grassroots message out there. And we want to do that with seller finance as well. And so as this bill comes forward, you will see us reach out and say, hey, please reach out to your congressperson. There's an easy process to do this. So look forward to that coming out. And that's a good way to build a national grassroots momentum to really help push this bill that's being worked on so diligently by Matt and the Seller Finance Coalition in DC. So other thoughts? What you mentioned Doge early on, and as we wrap up here over the next couple of minutes, final thoughts. What are you seeing from a tone, from a perspective? I mean, we see headlines and hear that, but what are you really seeing?
It's a great question, Charles. I've been doing this just about 30 years. And this week, I've been asking everybody that I'm meeting with, what do you think of the pace of what's happening right now? And everyone has agreed that it's 100% more intense than anything that they've ever seen or been part of before. And it's being dictated really straight from the Oval Office down to the Congress as well. The president's a guy that only sleeps about 4 hours a night, and you can tell that by his X feed and by just the sheer volume of what he's been doing. Whether or not you like him is up for debate for a lot of people, but you can't take away that he's the hardest working man in show business for sure. And to go from the pace of Joe Biden to the pace of Donald Trump after 4 years of being out of office, really having learned a lot of lessons from his first 4 years, he's just a totally different caliber of an executive at this point. He's moving at lightning speed. The Doge thing has changed literally everything. When was the last time we had serious conversation about really hacking into the federal bureaucracy and the federal government? And, both Elon Musk and President Trump have said this is just the beginning. We're going to keep our foot on the gas for 4 years and really try to make the federal government more mainstream, run more like a business, and make it more efficient for the American people. You're going to see a lot of things privatized that have been done by the federal government for a long time. A lot of those things have been done inefficiently and not well. And I think that's going to change. And people are, as you can imagine, resistant to that change. But you're also seeing for the first time, large swaths of the federal employee base being either retiring, taking the early retirement, or being sent into the free market. So it's been, something for business owners, like everybody on the call, and investors. It's going to be a much friendlier environment than it was for the last 4 years. I recommend engaging, as you said, as a group is critical. I've been telling groups like everybody on the phone, this is the time to throw the ball down the field and really take some shots at scoring touchdowns. And the sooner you get in to do that, that's why we started day after the election to start talking about the agenda for this Congress, because we want to be ahead of the curve and ahead of the line. And if you were here today, Charles, the lines to get in the buildings are about a half hour because there's so many people that are here. And luckily, through your efforts and people like Jeff Watson and Eddie Speed and some others, we've been ahead of the curve, putting our stuff out there first and foremost.
Excellent. I think it's going to be interesting over the next couple of years when, as Justice Kelly said, and we were talking about, you're attacking the structure of the government itself, separating out that bureaucratic power back to the legislature and the judiciary, and then also coming at it from a funding side and, even breaking it out and saying, what are we actually spending our money on? And shedding light on that facet of it. At the same time, there's been a conversation going that I think is really being asked, which is, it's not just about having efficient government, but is this something the government should be doing? And that question is going to continue on.
Yep, absolutely. And it needs to be asked. We're $30+ trillion in debt, and we're going the wrong way. And we have to start clawing back some of that debt. And, what President Trump said just last week, his aim during his presidency is to have a balanced budget by the time he's done, which would be, a long way toward turning that cost curve.
Well, Matt, I just want to say thank you for popping in. I know you're holed up somewhere in Rayburn there. Appreciate it. And this has kind of been one of those, a lot to throw at everybody very quickly, but I do want to say thank you, Matt, and I look forward to seeing you in a couple of weeks. I'll catch up with you. But we'll be getting a little more information out, and as these pieces come forward, things that we can weigh in on, folks, we need you to weigh in. It is absolutely imperative that we have that national response.
Yeah, it goes a long way, Charles. One of the reasons why we were able to get more co-sponsors than we had the previous Congress was people from the REIA weighing in through voter voice and getting people like Diana Harshbarger in Tennessee. And she's like, all of a sudden I'm hearing about this issue. I'm getting on the bill. So the more we do that, the better.
Excellent. All right. Thank you very much, Matt. Everyone, just want to say thank you again. Just a reminder, we will be kind of doing some follow-up on this. This email, you'll get an email link from this. It's recorded. And again, I encourage you to share it out as the issue, the fact patterns and such. Make sure that gets out to the local attorneys. Make sure you've got, whether they're handling the eviction side of things or larger housing issues, please let us know. We're going to be sharing some more information out on Real Estate Investing Today's site, and just there's going to be some information coming out about folks who are behind the scenes on the AFFH rollback, some other things that are going on, and pay attention to those because there's some experts that have been in the government and some that are going back into the government that are providing information to us and we're working with. So we are getting some real opportunities, as it were. So I look forward to seeing everyone next month, some folks just in a few weeks. And thank you again for being here today. Take care. We'll see you.